Yes, sir.
Good afternoon, Your Honors. May it please the Court. William Milliken on behalf of Appellant Karen Howell, and with the Court's permission, I'll reserve 4 minutes for rebuttal.
Yes, sir.
This appeal concerns Ms. Howell's petition under the Post-Conviction Fingerprint Analysis Act of 2021. The Post-Conviction Court erred as a matter of law in denying Ms. Howell's petition. The Court reasoned that Ms. Howell still would have been subject to a conviction for felony murder, even if the results of the requested fingerprint analysis had been favorable. Respectfully, that is not the right question. The issue is whether the evidence could have led to a more favorable sentence for Ms. Howell, not whether it would have exonerated her altogether. The post-conviction court asked the wrong question and therefore reached the wrong result, and therefore this court should reverse. Now, Ms. Howell is currently serving a life sentence for her role as an accomplice in the tragic murder of 3 members of the Lillard family in 1997 when Ms. Howell was 17 years old. She's been in prison for more than 25 years, over half her life. And Section 405 of the Fingerprint Act, which is the section that Ms. Howell petitioned under, provides that incarcerated individuals may obtain a fingerprint analysis at any time if they can show a reasonable probability that had the results been available at the time of the original sentencing, they might have led to a more favorable sentence. And reasonable probability is a low standard. It means only a probability that's sufficient to undermine our confidence in the outcome of the sentencing. And so the question on these particular facts is this: if a fingerprint analysis had showed that the firearms in the Lillard murders had shown conclusively that Ms. Howell was not the shooter and that in fact 14-year-old Jason Bryant was the only shooter, would that undermine our confidence in the appropriateness of Ms. Howell's sentence of life in prison without parole?
Counsel, the sentence was the result of a plea, right?
That's correct, Your Honor. It was.
And so Ms. Howell presumably was aware of the facts of her case. Ms. Howell presumably at the time she was accepting the plea would have suspected or maybe actually known whether her fingerprints were on the weapon or not. So we're not talking about a case here where you have a sentencing hearing and the trial court is trying to debate where you sentence inside of a range. This is a plea that she's accepted.
Well, there was a guilty plea, Your Honor, but then there was a sentencing hearing at which time the court had a choice. It could impose a sentence of life with parole or a sentence of life without parole. And the court, based on, among other things, its conclusion that it wasn't sure who all were the shooters or what the extent of each individual defendant's involvement was, the court chose the maximum possible sentence of life without parole for Ms. Howell. And I think also that the circumstances of the plea agreement are important here, because the deal that the prosecutor offered to the defendants is that everyone had to accept a plea to first-degree felony murder. Otherwise, the state was going to seek the death penalty against the 4 adults. The 2 juveniles, Ms. Howell and Mr. Bryant, of course, were not eligible for the death penalty. And had it been clear that one of the juveniles, specifically Mr. Bryant, was the one who had actually pulled the trigger, then the state's ability to seek this package plea deal, sort of the credibility of their threat that they would seek the death penalty against the 4 adults, could have been undermined. And so if this fingerprint evidence had been available at the time, it's possible that this package plea deal would have never been in the picture, and I think there's a reasonable probability that the end result of that would have been something less than the maximum possible sentence for Ms. Howell. But
the result of that would have been a trial, right?
Had there been no plea agreement, there would have been a trial. And I would note, as several of the post-conviction courts in this case also noted, Ms. Howell herself had nothing to lose by going to trial. The sentence of life in prison without the possibility of parole was the absolute worst that she was facing because she was a juvenile ineligible for the death penalty. The only benefit she received was the fact that the state agreed not to seek the death penalty against the 4 adult co-defendants.
But that was obviously a decision that she made, and I assume this has been litigated quite a bit, has been affirmed. What difference does it make, really, when you get right down to it? From what I understand, reading through this, it wasn't suspected she was a shooter anyway. I mean, I think the plea was, her conviction was not based on her being the shooter. It was, she was an accomplice. She was criminally responsible for the other person's actions. So whether her fingerprints were on the pistol or not really wouldn't change the calculus, would it?
Well, respectfully, Your Honor, I would disagree, because I think there was a fair amount of confusion in the record at the time of the sentencing about who precisely was involved, about who did what, to the point where the sentencing court found, in a finding that this court later found was erroneous, that Ms. Howell had committed mass murder. And then there was a statement in this court's opinion on appeal from the sentencing that Ms. Howell had gunshot residue all over her. We now know that that's incorrect. The gunshot residue report, which is in the record, shows that Ms. Howell did not have any gunshot residue on her clothing. And I think that this sort of gap in the evidence, which was created by the prosecution's decision not to test the firearms for fingerprints, was sort of filled by the prosecution's story that these murders were part of some satanic gang initiation ritual that all of the defendants had to participate in, or otherwise, you know.
Let me stop you for just a second.
Certainly.
So the gun was never processed.
That's correct, Your Honor.
How in the world can anybody with any confidence say that that gun is in the same state it was when it was recovered and therefore has forensic value to get fingerprints off of this many years later?
Well, Your Honor, the state has not made that argument. That they have not argued that they no longer have the firearms, or that the firearms are in.
The firearms may still be there, but were they preserved in such a way that the fingerprints would be preserved, or there wouldn't be more if anybody handled it, their fingerprints are going to be on it? I mean, that's when I talk about forensic value, it would have to be consistent to when it was recovered in order to have value.
Certainly, Your Honor, and candidly, I do not know if the firearms are in a condition where they could still be reliably analyzed.
Isn't that a threshold question, though, before you can ask for this kind of thing? I know it is with DNA evidence. You have to establish that it's preserved in such a way that you can get a result. I mean, has this been preserved? Has it been stuck on a shelf for 25 years? Do we know?
Well, I would submit, Your Honor, we have no reason to believe otherwise. We have no reason to believe that the state hasn't preserved the evidence in a proper condition. And again, they did not make this argument below. They have not argued on appeal, and they are the party that is in possession of the evidence. And
how about this? We ask it just maybe slightly differently.
Okay.
Did the post-conviction court make a finding on this point?
The post-conviction court did not, Your Honor. The post-conviction court reasoned, and I think this is really the crux of the appeal. The post-conviction court respectfully did not engage with the substance of our argument about how Ms. Howell's incentives to plead guilty could have been reduced, about how the sentencing judge might have looked on her more favorably if this fingerprint analysis had been available. Instead, the post-conviction court focused on the fact that no matter the results of the fingerprint analysis, all 6 defendants would still have been eligible for conviction for felony murder. The state disputes our reading of the post-conviction court's opinion on appeal, but I think that the opinion speaks for itself. No fewer than 5 times over the course of 2 pages, the post-conviction court emphasized that the evidence couldn't result in exoneration. Pages 99 to 100 of the record. The court notes the defendants in this case were prosecuted for first-degree felony murder. This is not a case where the petitioners claim the fingerprint evidence will exonerate them or even establish a potential defense. At page 100 of the record, the extensive record of this case makes it abundantly clear that the state was not lacking in evidence to obtain a conviction for first-degree felony murder. You can see additional instances of this later on page 100 and on page 101. And the final one that I'll draw to the court's attention, at page 100, the court says, the petitioners would all still be guilty of the exact same crime, facing the exact same punishment regardless, and this court is not willing to engage in a fruitless waste of taxpayer dollars, to try and satisfy inquisitive minds when the results would have no material legal significance.
So did the trial court also find, though, that Ms. Howell was not the shooter and that she was a minor participant in the crime?
Your Honor, are you referring to the sentencing court or the
post-conviction court?
The post-conviction court believe that it read the sentencing transcript to mean that the sentencing judge sentenced Ms. Howell on the understanding that she was not the shooter. I think that...
And that she was a minor participant.
And that she was a minor, yes, that's correct, Your Honor.
If the sentencing judge was of that opinion at the time, how does the absence of her fingerprints on the firearm then adjust the sentence? So if you say she got the maximum possible because it was life without parole,
Right.
what in the nature of the fingerprint on the weapon have to reduce that sentence to the possibility of life with release if the sentencing court is already convinced that she was a minor participant and she was not the actual shooter?
I think, Your Honor, that if it were clear that the sentencing court sentenced her on the understanding that she absolutely was not the shooter, didn't take part in the killings themselves, then we wouldn't be here, because then I think the fingerprint evidence wouldn't have a reasonable probability of
Help me
affecting the
understand
outcome.
then why we believe that the sentencing court thought otherwise.
Because the sentencing court, when sentencing Jason Bryant, said, effectively, I think that you were one of the shooters, but I think that there was more than one shooter. The sentencing court seemed to buy in to this narrative that the prosecution was pushing, that sort of everybody did everything because this was part of some occult ritual that all the defendants had to take part in to make it work. And so my submission here today is that had it been absolutely clear that that theory of the case was not correct, that this was not sort of a joint ritual where all six individuals were playing some part in the killings themselves, then that reasonably could have had an impact on Ms. Howell's sentence, given her age at the time of the offense and the other applicable mitigating circumstances.
But if the sentencing court says on the record that Ms. Howell was not the actual shooter, doesn't that defeat then the state's theory, as you put it, that everyone was involved in everything?
I'm sorry, could you ask that question once more?
I thought you and I had more or less agreed that the sentencing court had concluded that Ms. Howell was not the actual shooter.
No, Your Honor, I disagree with that. I think that that's how the post-conviction court reads the transcript, but I do not agree with that reading of the transcript. I don't think it's clear from the sentencing transcript that the sentencing court knew Ms. Howell was not the shooter, because the court made reference to the fact that he believed that there was more than one shooter.
Where were the guns seized?
I'm sorry, Your Honor.
Where did law enforcement seize the guns?
I believe, Your Honor, that they would have been seized when the defendants were detained in Arizona following their reentry across the border from when they had been in Mexico.
How many days was that after the shooting, killings?
I'm not sure the precise answer to that question, Your Honor, but I think we're talking about a matter of a few days to a couple of weeks, something like that.
So we're talking about the fingerprints that would be on the gun, assuming they're still there, at the time it was seized at the Mexican border, not the fingerprints that were on the gun immediately after the murders of the Lily Lakes, correct?
That's correct.
How does that tell us anything about this case?
Well, if, for example, there are no prints of Ms. Howell's on the guns that are consistent with her having fired it, then I think that would tell us that she didn't fire the gun and definitively was not a shooter. How does
it definitively show that? Maybe she was a shooter and used gloves. Maybe she was a shooter and the guns were wiped down following the murder. Maybe Mr. Bryant wasn't a shooter, but he handled the guns after the murder. There are any number of possible scenarios that could take place here, given the fact that these guns were seized days after the murder. Do you not agree with that?
I agree, Your Honor, that there are different possible scenarios and that we don't know what the results would be because the guns haven't been tested. But as the Tennessee Supreme Court observed in the analogous context of the DNA Analysis Act in the State versus Powers case, you don't have to show that the evidence is going to conclusively establish a better sentence or a showing of innocence. You just have to show a reasonable probability that the evidence might undermine our confidence in the outcome. And
Well, let me stop you there, because the statute has two parts.
Yes, Your Honor.
One part talks about undermining the confidence in the verdict, and that's part one, that says basically the court shall grant if the fingerprint evidence could possibly show actual innocence.
That's section 404, yes, Your Honor.
The other section says may, if it could possibly result in a lesser sentence. So there's a big difference between shall grant and may grant. In this particular case, you come under the second part because it's not going to go to actual innocence. Clearly, under the theory the state proceeded under as criminal responsibility, they're all guilty, every last one of them.
I agree with that, Your Honor.
You're dealing with whether or not she could have gotten a lesser sentence. And that comes under the heading of the court may grant. So the court sets out a number of reasons why the court doesn't feel that it is appropriate to analyze this fingerprint evidence, that it wouldn't have really changed anything based on what happened. What is the standard of review we have under that? How are we supposed to assess that, since it's may, it's not shall, it's may? And obviously, the court then has a discretion to decide whether or not it's going to grant that.
Correct, Your Honor, but I think it's important to note that the post-conviction court here did not say, I find that there is that there is a reasonable probability that it might change her sentence, but as a matter of discretion, I am not going to order an analysis because I have discretion under section 405. The basis for the court's decision was its view that the evidence could not undermine the confidence in the fact that she was eligible for conviction for felony murder. I would submit that that is an error of law, which is by definition an abuse of discretion.
You've run out of your initial time, so you
Yes, sir.
We'll hear from you in a minute. Okay.
Thank you.
Sure. State.
Good afternoon, Your Honors. May it please the court. My name is Alan Groves on behalf of the state of Tennessee. Karen Howell was an accomplice in the...
Can I interrupt just quickly to touch on a point that we were touching on here previously?
Sure.
So the post-conviction court's order does not address the other factors that it must address in order to grant or deny relief, including, it seems, whether the evidence is still being preserved in a way that it can be forensically tested. Do you agree that the trial court did not make those findings?
I agree that the post-conviction court stopped after the first factor and found that that was not satisfied.
Is there case law that suggests that the trial court should have considered all four factors and that this court should remand?
If the court were to find that the post-conviction court erred with respect to that first factor, then I think possibly a remand would be appropriate. But I'm not aware of any cases holding that the failure to address all four factors would necessitate a remand just in the first instance, even if that finding was correct.
Are you aware of State versus Downs from December 18th, 2018? When in that case, it looks like this court held that the trial court should have considered all four factors. We reversed and remanded.
I don't believe that case was cited in the briefs by the parties, but I've come across several cases where this court, for instance, has been reviewing the post-conviction court's decision on these DNA and fingerprint petitions, and as soon as it finds that the first factor, either under 404 or 405, was not satisfied, then this court stops the analysis and doesn't continue to analyze factors 2, 3, and 4. So I would imagine if that's the way this court typically handles the cases, that the post-conviction court would be within its right to also dismiss a petition solely based on factor 1.
Okay, but in this particular case, factor 1 really was, I guess I want to focus on what we're actually talking about. The argument that I'm hearing here today is from the petitioner is that they're operating under the second part of the statute dealing with maybe would have gotten a more favorable sentence.
Yes.
Not under the first part that dealt with the conviction itself. Was that the argument that was made at the trial court, and the trial court only considered this other section?
Yes, Your Honor. The petition itself identified Section 405, the discretionary provision under the Fingerprint Act, as the basis for relief, and that's what the post-conviction court analyzed. And to be more responsive, Judge Greenholz, I think this is very similar to like the plain error review that this court conducts when a defendant has waived plenary review. If the defendant fails to satisfy a single element of that test, there's no reason to go on to consider the other elements. I think if the court were to find, though, that the trial court...
I don't disagree, and there are cases holding your way. I'm curious, though, that there are some cases, Nelson v. State from 2011, Downs as I cited, where you may have another element that's at issue. This court has remanded before for findings on the other factors. And it seems to be pretty important to know whether the firearm is still in a condition that it can be forensically tested.
I think in the interest of judicial economy, if this court agrees with the post-conviction court that there's no reasonable probability that this evidence would result in a more favorable verdict or sentence, there's no reason to remand.
Well, so your friend on the other side says fundamentally there is an abuse of discretion, and I'm hesitant to use that term, but that the trial court simply just didn't apply the right standard, because in the context of someone having to show actual innocence, it doesn't make a whole lot of sense to require that showing if what we're talking about is a more favorable sentence.
Okay, so there's a couple issues in there in that question. Number one, the post-conviction court expressly did not consider whether this petition was filed to demonstrate innocence. But to this other point about there's an error of law in the way the trial court conducted this analysis that constitutes the abuse of discretion, I completely disagree with that characterization of the post-conviction court's ruling. And to explain why, I have to back up and identify the two bases for relief that were identified in the fingerprint petition, because the post-conviction court was responding to these two different theories, and that's very important.
Yeah, please do.
So the first theory was that finding favorable fingerprint evidence on the fingerprints of Bryant would have materially reduced Howell's incentives to plead guilty in order to spare the other adult co-defendants from the death penalty. And so the post-conviction court's analysis that keeps being referenced by the appellant is the analysis related to that point. The only way to make sense of that, that this type of evidence would have materially reduced her incentives to plead guilty, would be to say that if we had that fingerprint evidence, she would have either gone to trial, as one of your honors mentioned, and gotten convicted of a lesser included offense, or maybe she would have pled guilty to a lesser included offense and thereby received a lesser sentence. That's what the post-conviction court was responding to. It wasn't conflating 404 and 405, the mandatory and discretionary provisions. It completely understood we were under 405, the discretionary provision. It seems to me that the defendant is almost abandoning that line of argument, because now we're solely focusing on the second basis for relief identified in the petition, which is just that if we could find Bryant's fingerprints on the murder weapons, that would just distance Howell from these murders generally, and that maybe the trial court would have found that was somehow mitigating, or that she wasn't as involved with this group of people as the state was making out. And now I can address that argument. It's also wrong because at the sentencing hearing, as counsel stated, the trial court was faced with two options: life without the possibility of parole, or life with the possibility of parole. So to make that determination, the trial court had to consider aggravating circumstances and mitigating circumstances. The trial court found three aggravating circumstances. One is the mass murder aggravating circumstance, which on direct appeal, this court said was applied in error because that particular aggravating circumstance has to be connected with the defendant who actually did pull the trigger, and no one really contended that Ms. Howell did. But the court still affirmed and said that it was harmless error because there were two other aggravating circumstances that were supported by the record, that the murders were committed to avoid arrest or prosecution, which applied to all three defendants that were murdered, and that the murders were especially cruel. That aggravating circumstance applied to Delphina and Tabitha. And so even if you take off the mass murder aggravating circumstance, you still have two others. And even in the defendant's reply brief, there's no discussion of these other aggravating circumstances and whether they still would have been applied, even if we had the fingerprint evidence that they think would be found if we were to conduct testing. And the trial court also at sentencing considered all of the mitigating evidence that Ms. Howell was able to present at this sentencing hearing. And that's quoted in a block quote in the state's brief. So it's not accurate to say that if we had fingerprints of Bryant on the murder weapons, that would in any way affect Ms. Howell's sentence in this case. And again, I want to emphasize that because the defendant has failed to show that there's a reasonable probability that she would receive a more favorable verdict or sentence, the court just doesn't need to address this fourth factor regarding whether she filed the petition to demonstrate innocence, which is really the factor that I think the defendant hones in on and discusses the most. I just don't think that that's necessary to reach. And that seems to be, again, how the court has addressed the issue in the past. Walks through the factors kind of in order, and as soon as you find that relief's not warranted based on factor one, the analysis just stops and the petition can be dismissed. I'll address briefly, to the extent there's any confusion on behalf of the court or any concern about what facts Ms. Howell actually admitted to as part of this plea, or what the trial court at sentencing was finding or relying on and imposing the sentence, I just want to emphasize that we have a very incomplete record in this case. The appellant has the duty to prepare the appellate record under Rule 24B, and we don't have a plea hearing transcript, we don't have the plea agreement, and we only have a very small portion of the sentencing hearing transcript, which was the trial court's oral ruling, specifically regarding Ms. Howell. There's a couple of pages like on both ends of that where the court's briefly addressing other defendants, but we don't have even the complete analysis of those. And so this court has held in previous cases that to the extent there is any question about a matter of fact that could have been addressed through a complete appellate record, that the court can presume that the trial court's findings and rulings were correct when there's an inadequate record. I believe I've addressed all the points I wanted to make, Your Honors. If there are no further questions, we respectfully ask you to affirm the summary dismissal of the fingerprint petition.
Thank you, Your Honors. I'll be brief. As to the factor of the statute that requires that the evidence have been preserved and still be available for analysis, we argued in our petition below, and you can find this at pages 10 to 11 of the record, that on information and belief, we believe the evidence was still available. I think it's fair for us to rely on the presumption of regularity to allege that on information and belief, and again, the state has never contended otherwise. They have never said that they no longer have the firearms or that they are not.
Well, the issue is not whether they still have it or not. The issue is whether or not it is still forensically viable, and that all depends on how it's been maintained. And I would think that you would have to have at least something to establish that the evidence is in such a condition that you could test it with some confidence. And as Judge Hickson mentioned, it was recovered many days afterwards at a different location, makes it more difficult to believe that there hasn't been other fingerprints put on the gun or fingerprints removed, assuming even you have fingerprints that were left behind, because they're not always, that doesn't always happen.
I agree that the forensically viable point is an entirely fair one, Your Honor, but the state hasn't made that argument either. They did not say below, they have not said on appeal that oh, these weapons are not in a condition to be tested anymore.
And the court never got far enough down from what you're saying is it didn't consider all the factors.
That is correct, Your Honor. And we heard today from my friend on the other side that in their view, the post-conviction court stopped because it found no reasonable probability that her sentence would have been any different. I just do not agree with that reading of the post-conviction court's decision. I read the post-conviction court to have found that there's no cause to grant relief here because Ms. Howell and her 5 co-defendants would have still been eligible for conviction for felony murder, even under the most favorable possible outcome that we can hypothesize of the fingerprint analysis. I don't think that's correct under Section 405, Your Honor.
Well, what I'm, if she went to trial, the assumption is, well, maybe she'd get a lesser. Well, maybe she wouldn't. It sounds like the proof was pretty strong, and then you've got a situation where it was based on a guilty plea. And if my understanding of what the rationale was, the guilty plea was for everybody had to plead, and it was in exchange for the adults not getting the death penalty.
That's correct, Your Honor. She might have gotten the same sentence. We don't know. But the standard here is reasonable probability, or is our confidence
And
undermined?
you still have the same aggravators that the judge found.
That's true, but I think it's important to note Ms. Howell's age at the time. She was a minor, and to observe that had the sentencing court had a full and accurate picture of who did what, and viewed the accurate picture in view of Ms. Howell's age and the other mitigating circumstances, namely her lack of a criminal record, her history of abuse and neglect, her low IQ, her high susceptibility to peer pressure.
What did she stipulate to? What was stipulated to at the guilty plea? We don't know.
That is correct, Your Honor.
And don't you think that's significant, though? The state puts out their factual foundation that the court has to find a factual basis for the plea. So the prosecutor would have to lay out the facts for that particular defendant to justify the sentence, to justify the conviction. What they said and what she stipulated to becomes pretty important.
Well, I mean, the facts were sufficient to establish a conviction for felony murder. No one disputes that because she was there at the scene of the murders, and she participated in the getaway. She was certainly a part of a felony that resulted in a murder. So that's not in dispute. I would just respectfully submit that's not the correct question.
I appreciate it. Thank you.
Thank you, Your Honors.
Thank you all.
Can I ask one more question?
Oh, sure.
Judge, I'm sorry, just one more question.
Certainly.
You started to go through the mitigating evidence that you said was presented at the sentencing hearing. I heard the state's counsel argue that the trial court, the sentencing court, considered all of the mitigating evidence. Is that true?
Yes, Your Honor. I agree with that. My point is simply that had the court considered those mitigating factors with a full and accurate factual picture of what happened, the outcome may have been different.
Okay, that's fair. Thank you.
Thank you.